Members, we have 26 bills to hear today. One is vote only, 2 are on consent. Because this is our last hearing, we have many bills that take on incredibly serious issues that go to the root of our public safety system, issues that come to terms with the need for consequences, issues of rehabilitation, and very profound issues of justice. I want to thank the staff and the authors of these bills for their very hard work in the recent weeks in sorting these issues out and seeking balance and justice for everyone in our society. We're taking the bills in file order. I don't see Senator Liu here.
I'm presenting for Senator Liu, but I'm happy to wait till the end.
To wait. Okay, thank you, Senator Anderson. So we're going to hear item number 2, SB838, Senator Bell, on juveniles. Thank you. Welcome to the committee,
Thank
Senator.
you, Chair and members. First, I would like to thank the chair and staff and members for working with me on this important bill. I will accept the committee's suggested amendments as author's amendments with some additions that our District Attorney Chris Ariola has suggested. The staff has those amendments. I will keep my opening brief statement to allow more time for witnesses. SB838, Audrey's Law, was prompted by the tragic death of a young woman in Saratoga, Audrie Pott, and I'm honored her family allowed me to author a bill in her name. As amended, the bill would close a loophole in a current law that treats rape and sexual assault of an unconscious or developmentally disabled person as a lesser crime. Additionally, it would update our sex offense laws to the 21st century by keeping up with the expanded use of social media. SB 838 would make any sex offense a more serious crime when the offender distributes or posts media of the incident with the intent to further harm or embarrass their victim. The bill is about equal justice and updating our laws to reflect the use of media in the 21st century. SB 838, Audrey's Law, has bipartisan co-authorship, enjoys the support of developmental disability community, law enforcement, victim rights advocates, and women's rights organizations. And respectfully ask your aye vote, and we have witnesses. And I'd like to turn it over to Mr. Pott.
Good morning, Senators, Madam Chairperson. My name is Lawrence Pott. I'm here today representing the family of Audrie Pott, who was my daughter. We strongly endorse this bill because of the crime that was committed against Audrey and what we feel was a lack of punishment and subsequent deterrent and the risk to public safety we believe exists, as well as the horrible message that we're sending to our communities with the current California law. On September 2nd, 2012, my daughter was brutally raped by 3 high school classmates while unconscious at a friend's home. During this attack, they took pictures of her naked body. Audrey was just 15 and a virgin. They shared these pictures via text message, and rumors spread through her school about what had happened. For the last week of her life, Audrey was forced to investigate her own crime, a crime she didn't remember. The more she discovered, the more devastating it was to her. Finally, she took her own life on September 10th, and after 2 days on life support, she passed away on September 12th, 2012. The rape and subsequent cyberbullying causing Audrey's death was committed by her assailants, and the ensuing impact that it's had on myself and my family is immeasurable. Rape is a crime against humanity. It destroys lives, always many more lives than just the victims. It destroyed Audrey's life. The number of friends and family members who've suffered because of this crime is incalculable. What we hope to accomplish in these hearings today and by your passing of SB 838 is the saving of all these future pieces of lives. As you may know, it garnered worldwide attention in the press because it alerted the public to a disgusting trend of raping unconscious victims. and the use of technology to document these crimes and harass the victims. We decided when we first found out about the crimes that were committed leading to Audrey's death, we said that no stone would go unturned in trying to discover and understand what had happened. We were and are determined to do everything in our power to give Audrey's life and death meaning so that her life and death would not be in vain. She made a difference in thousands of lives while living, and we believe she will make a difference in thousands through her passing. SB838 is easy to understand and makes perfect common sense. Both 676A and B and 707B close a loophole that is not apparent in the adult penal codes, nor anywhere else in any penal code. This random loophole in the juvenile code makes the law ambiguous. It gives rape two meanings, when there really is only one. In 2013, the Federal Bureau of Investigation changed its definition of rape. It had not been changed since 1929. The current FBI definition of rape is penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. This is exactly what happened to Audrey. You see, her crime met the federal definition, but not California's. Her assailants should have been charged with rape. Instead, they admitted to just sexual assault and received a minimal stay in juvenile hall. Two of them received just 30 days, served on weekends, the equivalent of Saturday detentions. The others served only 45 days. They're currently on probation, and although they have been ordered to perform community service, to date they have done nothing. The probation program is not designed to help these types of criminals, and even the probation officer assigned to this case recommended that it be escalated to adult court. Rape is always forced. It is always a violent crime. If you drug someone or find someone incapacitated for whatever reason and murder them, it's still murder. If you drug someone or find a mentally incapacitated person and kidnap them, it's still kidnapping. If you drug someone or find someone incapacitated and then rape them, it should still be rape. It's certainly not a lesser crime. In fact, if you ask 100 people on the street or in this room, all of them will not believe you when you tell them the current law. They will tell you the penalty should be more severe, since the victim could not fight back, not less severe. This is a common sense bill, and we believe it is highly supported and will do the public much good. The creation of Penal Code Section 290.1 addresses the need for laws to catch up with technology. The taking of a photograph during a sexual crime and then disseminating that photograph in any way, shape, or form to intimidate, harass, shame, or bully a victim should be a crime. This is another common sense law. Since the advent of photography, we have had photo development gatekeepers. That is, if you were to go to Walmart or back in their existence, the Kodak booth with a sexually explicit photograph, they wouldn't even develop the picture. In fact, they won't today. If it looked like a crime had been committed, they will call the police. Well, guess what? We don't have the Walmart photo tech to watch the gates for us. And technology is making these photos and their delivery available at cyber speeds. SB838 will at least provide some level of protection and an enhancement to a sexual crime when photos are taken. We've had numerous women, old and young, and men approach us and thank us for what we're doing. They've told us about their being sexually assaulted. And in some cases, we're the only people they've ever told. They tell us they understand why Audrey and these other young women are taking their lives. You see, it's because in their cases, before the advent of technology, no one knew. Maybe in their later years, a trusted friend or counselor, but that was it. And they could still barely carry on. But to think that Audrey had to relive the rape and believe that everyone in her school and her world knew, and that pictures were out there, it was as if she had been raped thousands of times and would never end. That is what technology has done to this timeless crime. It has made rape worse than it ever was. Please, senators, do not back down to the special interests that serve the less than 1%. They will have you believe that they need this loophole for the criminals they protect. Do the right thing and serve the 99% that believe rape is rape. Remove the loophole. Our family and the 5,500 people who signed our petition for this bill respectfully ask for your aye vote in Audrey's memory. Thank you.
Others in support of the bill.
My name is Lisa Pott. I'm Audrey Pott's stepmother. For all the reasons stated and in honor of Audrey's memory, and for justice, equal justice for rape victims under the law, I urge you to please vote for SB838, Audrey's Law.
Good morning. I'm Sheila Pott, Audrey's mom. I can tell you throughout the past several months, each and every person that I've spoken to about this particular loophole in the law that does not see that rape is rape and distinguishes between an unconscious victim and a forcible rape is outraged. The only reason they don't know the difference and that loophole exists is because they haven't had the tragedy and haven't had to work through the system that created that loophole. I've also met with many other victims that have come forward and mothers of children that have fell victim to this. I can tell you that there's so many more out there. They don't come forward because they don't feel that the system protects them and they don't want to be re-victimized again. Rape is rape. We need this changed. Please, I urge you for your aye vote.
You might just do Me Too's at some point. I think that we've been very, very consumed with our feelings about this and the need to take some other steps.
Chris Ariola with the District Attorney in Santa Clara County on behalf of Jeff Rosen. And he just wanted to let you know that we've seen these cases all over the country. Tragic scenarios that seem almost perversely scripted. A young woman, a group of men, alcohol, sexual assault, social media, and then sometimes suicide. The laws of our state are crafted. The laws of our state are crafted and evolve along with the crime we are forced to face. California's laws have not yet evolved to address the unacceptable 21st century tragedy of young Audrey Pott. As an office, we cannot by law and will not speak about the specifics of Audrey's case, but I have the responsibility and a duty to talk about public safety. And I feel I must talk about how victims of sexual assault and their families are no less devastated because the offender or offenders were juveniles. I must talk about Audrey's legacy. Through this proposed law, Audrey's legacy is about protecting victims' rights by making the criminal consequences of sexual assault and consequent cyberbullying more severe and just. Let me explain. Under today's current law, if a group of young men hold down a young woman and rape her, they can be charged in adult court with adult charges. But if those same young men instead ply that same young woman with alcohol and then rape her, they must be tried in juvenile court. There is no difference in the trauma, the devastation, and the egregiousness of these crimes. And in many ways, they're more egregious because they take advantage of truly vulnerable victims. Yet the young men in this latter scenario will face only the juvenile court's far less stringent outcomes, diversion, and other protections, and including anonymity. Now let's add yet another layer of frustration and outrage to the already unjust scenario. Let's say that one of the rapists takes photos and a video. In fact, I filed 2 cases like that in anonymity this month, where the victim videotaped the rape and sent it to other people. And the sexual assault on a smartphone. He shares these videos with a friend who then posts it to social media or internet or text. And under current law, we have really no way of enforcing that. For example, if they send the photos and they say it's not for a sexual purpose, it's only to harass, they can get around child pornography laws. Under Audrey's law, we could file adult charges against people who sexually assault heavily intoxicated, mentally disabled, or unconscious victims. The time has come to pull these predatory perpetrators out of the shadows and make the justice system live up to its promise to protect victims and let them choose what will be public and what will not. By allowing for increased penalties and a public forum for many of these cases, everyone will be held accountable and the public will be better educated. And we send the message that no means no. Unconscious means no. Mental disability means no. Intoxication means no. We will have no tolerance for anyone who, even though they were not there participating in these non-consensual and criminal acts, makes the choice to humiliate or harass someone who has been the victim. Let's be perfectly clear. This is a serious crime. Audrie's law makes it easier for prosecutors to hold cyberbullies accountable and rapists accountable. Audrey is gone, and we are here today to see if we can make some sense out of the senseless tragedy, and we ask for your help today.
Thank you. Again, others in support?
Senator Hancock and committee members, Daniel Savino with the Association of Regional Center Agencies, or ARCA, which represents California's 21 nonprofit regional centers that provide intake, assessment, and service coordination for over 265,000 Californians with developmental disabilities. We've heard a number of excellent reasons why this bill warrants support, and we're here to speak briefly in addition of one more particular reason. People who have been incapacitated because of intoxication or other circumstances warrant this protection, and we express our deep appreciation of Senator Bell's wisdom in recognizing that there's another group who are uniquely vulnerable in that same way, but it's not merely a passing evening, it's not a moment, but can be a lifetime. And those people are found within the community of those who have physical or developmental disabilities. Many people with developmental disabilities live, love, and work in the community ever more integrated into the world around them, but there are those who are uniquely vulnerable because of that disability. If they are a minor, and their assailant is a minor, as we've seen here, that incapacitation of a physical nature would leave their perpetrators, their victimizers, their assailants in a loophole that would allow less justice to be found. We very much appreciate and thank the Senator for authoring this bill because it would expand those protections to those with developmental disabilities. So for the reasons previously stated, and for this, we very much strongly urge support.
Madam Chair, members of the committee, my name is John Lovell, and I'm here on behalf of the California Police Chiefs Association. In addition, two of my other clients, the California College and University Police Chiefs Association and the California Narcotic Officers Association. This is a good sense bill arising out of a horrific act that truly shocks the conscience. We strongly support its enactment.
Thank you. Others in support of the bill?
Connie Valentine, California Protective Parents Association. We urge your aye vote. Thank you.
Jackson Toomey, Courageous Kids Network. Rape is very bad. Everything you all have said covers the way I feel. We support the bill.
Good morning, Shannon Smith-Crowley, representing the American Association of University Women for California in support. We ask for your aye vote. Thank you.
Joelle Castex, Western Regional Director of SNAP, the Survivors Network of Those Abused by Priests. We are in support of this bill.
Kim Bresden, I'm just a private citizen, but I'm a family friend of the Potts. Audrey was a lovely young woman, and I strongly support this bill.
Daryl Bloomdahl, Napa, California. I urge you to support this bill.
I'm Nancy Norris from Sunnyvale, California. You have a wonderful opportunity to make a real change, do the right thing. I urge you to support this bill.
Denise Lawman, San Jose, California. We've heard a tragic story today. I urge you to pass this bill.
Thank you.
Dr. Charlotte Laws, the mother of a revenge porn victim and a board member of the Cyber Civil Rights Initiative. I support this bill.
I'm Marion Paula from Hampton Bay, Audrey's aunt. I support this bill. Thank you.
I'm Sam Spieler, Audrey's cousin. I'm from Los Gatos, California, and I support this bill.
Thank you.
My name is Andrew Blumen. I'm here to support the bill. Just wanted to make one passing comment. The law as it stands right now seems to strangely empower the victimizer. and we need to put laws on the books that protect the victims and make sure they don't get re-victimized.
Thank you.
Thank you.
Thank you.
Bishop Ron Allen, CEO and President of the International Faith-Based Coalition, and we support the bill.
Bishop Kenneth Lee Davis, pastor of Encouraging Faith Ministries and member of the International Faith-Based Coalition, and we strongly and we urge you, please, we do support this bill. Please pass it.
Thank you. Are there others in support of the bill? What I'd like to do at this point, before we ask the opposition to come up, is have the staff review the amendments that were taken and that were accepted by the author. Let me say that all of us who worked on this in the committee really share the heartbreak, the anger, and the frustration that people connected with it. Those of us who read about it in the newspaper feel. We need to look for ways to stop cyberbullying, and we want juvenile offenders held accountable. For many of us, the most shocking thing was the fact that there appeared to be no real consequences. Now, under current law, those young men could have received years in DJJ. They did not, for whatever reason, we won't know. But what this bill does is ensure mandatory minimum time in placement. It ensures a public forum. You can no longer have closed cases, and does other things to ensure that this cannot happen again. And I think that it might be wise if we just went over what the amendments are, because it may change what some of the opposition thinks or modify it. But at any rate, we should get it out there.
The amendments accepted by the author would do the following things. It would require that if a minor is adjudicated in the juvenile court for a sex crime, that's specified sex crimes noted in the bill, when the victim is prevented from resisting due to being rendered unconscious by any intoxicating, anesthetizing, or controlled substance, or when the victim is at the time incapable because of a disability of giving consent, and this is known or reasonably should be known to the person committing the offense, the court's order shall include, but not be limited to, a minimum of 2 years out-of-home placement, which is the term of art relevant to a juvenile court adjudication, with mandatory treatment. In addition, minors adjudicated to have committed those specific offenses would be ineligible for diversion, deferred entry of judgment, under Welfare and Institutions Code Section 790. The 707B provisions of the bill would be removed. The bill's current provisions concerning open juvenile court proceedings would be focused on those specific offenses that I just enumerated. And then, in addition, the cybercrime enhancement in the bill would be refined to also state that it would apply to juvenile adjudications, not just convictions in adult court. And the term identify would be deleted from that provision. Senator, I believe that reflects the amendments as offered by the author.
I believe so, too.
That's a summary.
Right.
You have to read every one of them.
Right. So, having said that, are there speakers in opposition to the bill? Oh, do we? 1, 2, 3. We do have a quorum of the committee, so I want to establish a quorum so we can move forward. Please read the roll.
Hancock?
Here.
Hancock here. Anderson?
Here.
Anderson is here. De Leon? Knight?
Here.
Knight is here. Liu? Here. Liu is here. Mitchell?
Here.
Mitchell here. Steinberg?
Okay, a quorum is established. We'll hear from the opposition. I'm sorry that we weren't able to give you more information on the amendments. We didn't finalize the amendments until last night after close of business. Well, after close of business.
Good morning. Thank you, Chairperson Hancock and Senators, and thank you, Senator Bell. My name is Elizabeth Calvin, and I am an advocate with Human Rights Watch in the Children's Rights Division there, and we have been strongly in opposition to this bill because it would increase the number of youth sent to the adult system. I want to thank this committee and also thank Senator Bell for the hard work that's gone into looking for a different path to address this situation. We can't withdraw our opposition, of course, until we've had an opportunity to look at the details, but we are eager to work with Senator Bell and are hopeful that a resolution can occur. And we are thankful that he and others have listened to the concerns of advocates for children. Thank you.
Madam Chair, committees, and Senator Bell, I also join in my thanks. My name is Rourke Stacy. I'm a criminal defense attorney and an expert in juvenile law. I'm also committed to having less children in the adult system. And I join in Ms. Calvin's statements about thanking all of you for working so hard and hoping we can find a middle ground so less children are in adult court and yet the right things are done by all concerned. Thank you.
Hi, I'm Hannah Ziegler from the Ella Baker Center for Human Rights, and we share the concerns of our two people sitting next to me that we believe that children should not be entered into the adult justice system, and that's our major concern with this bill as well.
David Warren, Taxpayers for Improving Public Safety. Unfortunately, we haven't seen the amendments, so we can't withdraw our opposition, but I'd like to raise 2 points. Number one, with the author and the witnesses who advocate this position seem to forget that the juveniles that will be transferred to adult custody will become further rape victims in a state prison because of their age. So what we're doing is adding more rape victims to a system in adult prison, and that must be taken into consideration in this legislation. Second, as the staff report indicates, juveniles' mental acuity and ability is different than in adults, and that must also be taken into consideration. But but we cannot regretfully withdraw our opposition until we've seen the amendments. Thank you.
Thank you. Are there others in opposition to the bill? If you wouldn't mind moving on so the other people in opposition can speak. Thank you.
Good morning, members of the committee. Sue Burrell on behalf of the Youth Law Center in San Francisco. Like others, we will be unable to withdraw our opposition until we see what the amendments are, but we are very grateful that the author has listened to our concerns about sending more kids into the adult prison system, and we look forward to working with Senator Bell, hopefully on some resolution of these issues that will better protect vulnerable people in our community, including people who are disabled, and having mechanisms that will actually prevent these kinds of crimes from ever happening again. Thank you very much.
Thank you.
Hello, committee. Thank you. My name is Frankie Guzman. I am an attorney at the National Center for Youth Law, and I'm here to oppose this bill as it currently stands, unless amended.
Good morning. My name is Laura Rodolfi, and I'm here on behalf of the W. Haywood Burns Institute for Juvenile Justice, Fairness, and Equity. And I'm also here to strongly oppose the bill as written and appreciate any consideration to resolve the issues.
Libby Sanchez on behalf of the California Public Defenders Association, expressing strong appreciation to the committee and the author's office for coming up with the amendments. We will review them, and we hope to continue to work with the author on this.
Liz Gimpers, in behalf of Legal Services for Prisoners with Children, also in opposition for the reasons mentioned before.
Madam Chairwoman, members, Francisco Lubac on behalf of the ACLU. Our principal objection was the 707B provisions. We defer judgment to wait to see the amendments. Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice will also be reviewing the amendments.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We oppose
expanding the number of juveniles that would be tried as adults. We promise to take a good look at the amendments. Thank you.
Good morning. Pat Arthur with the Coalition for Youth and Community Justice, an alliance of more than 30 youth justice organizations in California. We greatly appreciate the amendments on 707B, and we'll look forward to reviewing them. And our concern has been putting more kids in the adult system, and we appreciate the amendments, and we'll withhold our withdrawal until we've reviewed them. Thank you.
Thank you.
Lizzie Buchan with the Center on Juvenile and Criminal Justice in San Francisco. And we appreciate the senators willing to work with us and look forward to reviewing the amendments. Thank you.
Thank you. Are there any others in opposition to the bill? Seeing and hearing none, are there any questions or comments from members of the committee?
Madam Chair, I'd like to move the bill when you feel it's appropriate.
It's appropriate now. The bill has been moved as amended to appropriations. Senator Mitchell.
Thank you very much, Madam Chair, and I really want to thank the author and the chair for working clearly late into the night diligently to try to come up with a compromise. This is one of those classic gray areas where when we hear about a particular case, it's so compelling. It's clear that there is a discrepancy in the law. I applaud your efforts around focusing on cyberbullying, Senator Bell, because that is an issue where I think public policy is going to have to catch up with technology in asserting how inappropriate those actions are and making sure that we are able to communicate that and that our laws reflect our concern around that. Based on the amendments, as I understand them, communicated by staff, and my quick read, I'm going to be able to support the bill today because my initial hesitance was a reversal of the work of this legislature to acknowledge current research around juvenile brain development and capacity, and my reluctance to see juveniles tried in a system designed for adults, to house them in a penal system designed for adults. And so with the amendments that we're taking today, I think it's a wonderful, balanced compromise where we can acknowledge that, particularly in this one case where justice was not served, but that we're not in a position where we're throwing the baby out with the bathwater in terms of future juveniles, that they will be sentenced, housed in a setting appropriate for them. And so with the amendments proposed, I will be able to support the bill today. Senator Bell, thank you.
Thank you very much. Senator Knight.
Yeah, Senator Bell, if you can just put me on as a co-author of the original bill.
Yeah, thank you.
Either way.
The original bill is no longer with us, Senator Knight. Okay. Senator Bell, would you like to close?
Well, I thank everybody for working so hard on this. I believe that the amendments that we're taking to this bill will make a improved system of justice for victims, such as Audrie Pot. I think it'll be clear that if you do that kind of crime and you're a juvenile, you will get a minimum of 2 years and possibly more. So it is a good thing. I think the open judicial proceedings is very important to have the rights of family members to actually watch and observe the proceedings of what is going on regarding the crime that was committed against their either child or person that was under their guardianship as an adult. And I also believe that the cyberbullying enhancement gives us a very clean, clear law regarding cyberbullying. A very clean, clear law. It's very clear. And we did work this out. I want to say this, that as somebody as somebody that has worked with developmentally disabled community my entire life, that I have to believe that this is a step in the right direction, but is not equal justice. This is not treating people that have developmental disabilities equal. We still need to go further on that. This does not deal with the developmentally disabled people in the prisons that are convicted of crimes, yet somebody that has a far greater intellectual capacity, even though they're under 18, is not put in adult prison. So we have a long ways to go for equal justice and to remove the stigma. I think some of our laws do have a sense of stigma, and I think it's time somebody speaks out on it. And that's going to be me, because I'm going to be speaking out on this issue. The courts do not treat, and the criminal justice system does not treat, people that are unaware of the crimes committed against them fairly. And therefore, they are victimized more. That is essentially what is the result of unequal justice. And we have to look at that, and we have to reflect on that, and follow up on that, and as a legislature, deal with that. So I urge your support for this bill. This is a step in the right direction. People that aren't aware of the crime committed against them deserve justice, and this is a good step in the right direction. I urge your vote.
Thank you very much, Senator Bell. And let me say you are right. So much more needs to be done. So much as a culture to make the kind of victimization that happened to Audrie Potts unacceptable, so that no man or woman would think about doing something like that, to help people who are victims come forward in time to be enfolded in the love of their community so they can heal. I do think opening this process and having mandatory consequences is very important in this bill. We will never know why the law was not enforced as it could have been, so that there were real consequences for the young men involved with this. I just wanted to say that many years ago, I was inspired by a young woman who was raped at her high school and went on to form an organization called Bay Area Women Against Rape. She told me she did it because she thought she could heal better if she could keep this happening from happening to other young women. I think the family should really realize what we are going to pass along today, I believe, will keep this from happening for other young women, and will ensure that there will be consequences if it does ever happen again. So thank you all very much for being here. I want to thank the author for working with us. I want to really thank the committee staff who worked long, long hours on this bill, the DA's office who we worked with as well. I think we're ready to have a vote. I ask the Secretary to read the roll.
Senate Bill 838, do pass as amended to appropriations. Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. De Leon? Knight?
Aye.
Knight, aye. Liu? Liu, aye. Mitchell?
Aye.
Mitchell, aye. Steinberg?
That bill passes. Thank you all very, very much. If anyone has come for SB 1233 by Senator Weiland, he has just sent us a letter that he's pulling the bill from the calendar indefinitely.